Hi everybody, my name is Shashank Tiwari. I'm a student at National Law School of India University, Bangalore, and I have a very interesting legal topic that we will be discussing today. The topic that we are going to talk about is about the appointment of ad hoc judges. And very recently, just a few days ago, the Supreme Court has come out with its latest ruling on what this means, and I'm about to explain it to you in this short video. Now, ad hoc as a term means need based or when necessary. So, the Supreme Court has set out new rules for the appointment of just judges when necessary. The first question then is, why are these judges necessary? Now, we all know that there is a lot of pending cases in the high courts today, and this number is estimated somewhere over 57 lakh. And that is a big issue for the Supreme Court because it is the apex court of the country. Now, out of these 57 lakh cases, 54 lakh of them come from just five courts. And that tells us that even though the number is so vast, it's still concentrated in a few courts. And this is simply because of the nature of the disputes or the type of people that exist in these places, not to hold any grudge against the judges or the legal system, but it's simply in terms of population and what the nature of these disputes are. Now, another issue apart from just increasing cases is that this is caused due to a lack of judges. Now, 40% of all posts are vacant, and this is something that the Supreme Court also took into account. Now, what they've decided is that recently retired judges or judges who will be retiring anytime in the near future will be appointed as these ad hoc judges. Now, we know that the current age of retirement is 62 years. So this means all the judges who are between 60 and 62, close to retirement, or who've just retired in the recent past, will be considered for this ad hoc appointment. And this is probably a good thing in terms of when we look at who should be appointed, because these are people who've just retired. And so they'll be more connected to the entire legal proceeding and the system as a whole. Even though this age 62 seems a little weird, out of all the democracies, we are one of the younger ones in the sense 62 years of age for retirement is still quite young compared to other larger democracies if we see. Now, what kind of cases will these ad hoc or need based judges be hearing? They'll be hearing only those cases which are extremely old, that are more than 5 years old. But still, there's always an exception, and the Chief Justice can intervene or give them specific cases depending on their subject area of expertise. So, if there's a judge who is an expert in criminal law and there is a pending case, or even if there's an urgent matter and there's a lack of judges, this criminal law expert can be referred a certain case or whatever, depending on the Chief Justice and the situation. But generally, they're brought in to look at cases that are really old, more than 5 years. Now, another thing that is involved in this is that these judges who've just retired cannot be giving legal advice, cannot practice arbitration or practice in court as lawyers or as act as consultants in any manner whatsoever, as long as they are ad hoc judges. So if someone is retired, they have to give up whatever they're doing right now if they are called on to be judges by the individual high courts. Now, where does this power come from, and can this even be done? Article 224A of the Constitution of India might be of help to us. Now, we know that this would fall under Part 6, Chapter 5 of Part 6 of the Constitution, and that generally between Article 214 and 231 speaks about high courts. And this particular Article 224A would come under that as well. Now, Article 217 of the Indian Constitution does provide for the appointment and conditions during office of a judge. This is also where the age 62 is particularly fixed right now. Article 224 of the Constitution, the objective at least, is to take care of the temporary increase in the cases that a high court gets and or any other issue that may arise. 224A in particular is very interesting, and this is what the entire section reads, or the article reads. Now, this article can be seen in three parts. The first part specifically mentions that a request can be made to the president, or once assent is granted, then any person who has been a judge before can be appointed, which means the first part of Article 224A gives us the power to do it. Now, the second part of 224A tells us that, and this is still within the first big paragraph, the second sentence or the second part of this tells us that these ad hoc judges who are appointed will have the same powers, privileges, and jurisdiction as a high court judge, which means these ad hoc judges will also have the same, pensions, these same housing facilities, the same access in terms of vehicles and stay. And in general court, they are considered as a judge through and through, except by title. They will not be called as a sitting judge of the high court. They are considered high courts only in, they're considered judges of the high court only in terms of the power they exercise and the duties they have, not in terms of title. Now, the last part, which starts with this little small paragraph, which starts from provided that, this merely says that the consent or the person has to agree to be the judge of the ad hoc high court, and they can't force to be, to take up this post. Now, the last aspect that this entire thing looks at is how this will affect the state governments and the individual high courts, because there are so many new judges coming in. Now, the Supreme Court made it clear that all of their payments, emoluments, endowances, pensions would come from the Consolidated Fund of India. Another question then that arises is that if you increase the number of judges, where is all this money going to come from? Now, the answer to that is very simple. These people or these ad hoc judges aren't coming as additional judges. They're filling up the vacancies which already existed. So no additional money is coming in, but rather the money that was supposed to be paid to, or the facilities that were supposed to be given to these judges are now being given to ad hoc judges or need-based judges. Uh, Apart from this, the Supreme Court has generally just noted that this would reduce the burden of the courts in terms of the number of cases they hear, and bring in some expertise in terms of some cases which are more than 5 years old. And these judges, having been retired, would know a little more about them, because in their practice, they might have seen or heard these cases in detail. Overall, this is a positive news in terms of the burden on high courts, but we still have to see how the Ministry of Law goes ahead with the plan, and generally how this pans out in the future months to come. Thank you. If you have any queries about this particular video or in general, please feel free to write us an email, and do give your feedback in the comment section so we can improve on our content in the future. Thank you.